Welcome. This is the Domain Name Law Show. We're here every Tuesday, noon Pacific, 3 p.m. Eastern. We cover domain name legal news. We review recent UDRP decisions. There's three hosts to this show. Myself, Todd Ryan, David Michaels, and Jeff Neuman. I'd like to say hello to my co-hosts before we get rolling. Hi, David. How's everything going today?
Good. It's nice and sunny here. Weather's more comfortable again. What happened to Jeff? I don't see him.
He'll be jumping in here. I was just on a call with him, so I know he's going to be here. See where he's at. So the Blue Jays. Looks like the Blue Jays and the Dodgers meet against you. Hey, so it's pretty exciting in that area that the Blue Jays are going to the World Series, David.
I didn't even know that. A whole bunch of people have been sending me messages about the Blue Jays. Yay! And I actually didn't. I missed the game last night. I was working.
Yeah, I it was an exciting game. I saw it, of course. I try to do like you. I try to work, look at the TV. I got one in my office. That's just catch it that way. But yeah, so okay, so exciting. L.A. Dodgers versus Toronto Blue Jays, fantastic. As I mentioned, so Jeff will be rolling in here shortly. We got three very interesting cases today. Profit.com, WhatsApp.ai, and Aeromotive.com. You might think that first case too, Profit.com, pretty easy case. How could someone go after such a name and think they have, any chance of success? Well, um, for the registrant, they were represented by a friend of the show, Igor Motsny, and Igor is going to be joining us to tell us a little bit about what happened with Profit.com, how it really wasn't as cut and dry as you might think. And boy, a lot of exhibits submitted in the case on both sides. Igor shared with me, so I look forward to Igor joining us when we get to our cases, which should be at least by the bottom of this hour. We'll try to get to it quickly and get through basically all the cases today fairly quick so we can get out of class early today. If we check the news, if to touch on a few news stories, and well, as we're waiting for Jeff to get in here, um, well, David, I want to talk about that Go.ai situation, but really more in a generic sense, not talk specifically about that case. But that's going to be story number 3. So maybe Jeff will be here by then. But if anybody wants to check and see what we're going to be talking about today, you can go to our outline, dnlshow.com/outline. And since ICANN 84 is the first note on the outline, I probably should push that back because Jeff is heading there. He'll be taking off Thursday to go to Dublin. That's ICANN 84 annual general meeting. And I have a link up on our outline if you want to attend just virtually, which I always do, unless, I've only been to one of them, I believe. Jeff's been to probably 80 out of the 84. But there's 3 meetings per year. This is the general meeting, but it's interesting, definitely, to attend virtually. You don't have to, obviously do it on your own time, your own schedule. Of course, they go by the local time. So Dublin is, I don't know, 8 hours, I think, ahead of where I'm at. So, you do have to adjust. There's a lot of sessions that'll be happening, late at nights or early mornings or in the middle of the night. But I would recommend anybody that's a domain investor, just interested in domains at all, you can attend these ICANN meetings and then you can make a decision if you ever want to attend one in person. I think they're fantastic to attend in person because ICANN is like, it's like, welcoming to everyone who wants to hear about, the internet, how it works, and the different agencies and organizations that really oversee what goes on online. But I was thought first class. I love the cookies. They got plenty of refreshments and stuff for attendees. David, have you ever been to an ICANN meeting?
I was trying to get into the one that came in Toronto in 1998, and the doors were locked, and I couldn't get in, so I missed it. I guess I didn't know which entrance to go into. It was at the CN Tower.
And for those,
Looks like
it truly is open
1988.
to the public, meaning you can just be anybody off the street. Hey, I use the internet, but now they do have some meetings. They had one that was for just registries and registrars, and pretty interesting. I was at one of their contracted party summits, which is mostly just registries and registrars. And of us domain investors, a lot of the registrars, you use them, especially all the big ones, and they're all there, you know, and some that are a little smaller, and I'll say small, but Pork Bun or Encirca that you may not use, but they're there. But of course, GoDaddy, Namecheap, Namebright, Dynadot, but they all have reps there. But there's some meetings what they try to keep sort of private. I'm a ICANN business constituency member, and anyway, there's not supposed to be any private stuff going on anyway. It's open, but I thought it was interesting. You watch people, make basically some arguments in public. They like to keep them private, but you see frustrations that sometimes registries have with registrars and in reverse. But there's always, talk about domain name, not necessarily disputes. They don't talk about what we talk about here very often, but definitely DN abuse is, a hot topic. And now the next round of TLDs is becoming a hot topic. Those are the sessions that I want to not necessarily participate in, but I want to listen in on. Okay, but anyway, there's a link on our outline. You can just click and you can sign up and say, hey, I want to attend virtually to ICANN 84 in Dublin, and it's very easy to do. And like I said, it's, I think, worth your time. Okay, next thing was heavy metal band Slipknot files lawsuit against Slipknot.com. This was an article on DNW. I thought it was interesting because it's a legal issue regarding a domain name, and it's almost something that people are interested in. Many of you probably heard of Slipknot. I know a lot of the headbangers out there, heavy metal. Anyway, they were around in the 90s, still around doing their big thing, but they're on slipknot1.com. That's always been their website, Slipknot1, and they have slipknotmerch.com. But they filed this lawsuit, and David, I thought they probably filed it because they filed a UDRP for the name and didn't get it, so they filed a lawsuit. Well, I didn't see a UDRP filed for slipknot.com, only this lawsuit, but I did see that they filed back in 2001. That's when I remember the Bruce Springsteen case and the Ice-T.com case. I was part of a lot of celebrities, or I say that was when it was first getting rolling. So there was a lot of filings back in the day for famous bands, like I said, famous people trying to get their names back by using this new policy called the UDRP. Well, anyway, Slipknot did win Slipknot2.com, the number 2, because they're on Slipknot 1. So I don't know. They went after Slipknot 2. They never did go after Slipknot. And Slipknot actually is a type of a knot, right? I mean, I think they teach you how to do that in the Navy or something. But anyway, maybe it's with boating, a slipknot. But so this lawsuit, since it's changed hands, or basically since it had some parking a PPC links on the page, and we're selling Slipknot tickets and some merchandise that they said was counterfeit. They think they have a good chance of getting this domain name. What do you think about Slipknot the band filing a lawsuit to get against the domain name? And tell us, David, what is an NREM? Because they filed an NREM case. Please let us know.
So they filed a combination case. So it's in rem and against John Doe's and ABC corporations. So basically, the in rem part is against the property, which is the .com domain name. And the rest of it is against these John Doe's who they don't know who they are, but they're naming their corporation, whatever it is, and whatever it changes to be, and who else is in the chain. But yeah, they've claimed both causes of action, and they're being pretty aggressive about it. So it's interesting. They only got their word mark in 2024. Since 2001, 2002 actually, they had Slipknot as a stylized mark in the same like jagged style they used to have on their T-shirts, which they show on their complaint. I never heard of it. It's not world famous, but it's famous in some parts of the world. Anyways, so I looked on Google Trends. They were big in the early like 2000s, 2005, 2006. Currently, they're only big in Brazil. Everywhere else is like nobody's talking about them, at least on Google. So do they stand a chance? Well, maybe, but you know what? There would be much better use cases for this domain name. Honestly, I would not park it with ads. And, maybe they didn't even know that there was a trademark for Slipknot. They just assumed that it was something for sailing and they didn't even change their ads because I know they're running it on Giant Panda. And when you use Giant Panda, you can change or you can do negative keywords for ads. So you can block out the tickets and anything that's trademarked. So I don't even think that came across their radar until they saw the complaint. Or we saw the allegation, the complaint in Domain Name Wire.
Yeah,
But will they win? I don't know.
yeah,
Maybe not.
sorry to interrupt you like that. No, I was going to say now that Jeff's here, we'll talk about this. We'll also jump back to the ICANN. But hi, Jeff, how's it going? Let's check your audio.
Good, good. Sorry, I was on the phone trying to find a hearing date with a court, and so you can't just kind of hang up on them. So apologies for being late.
No sweat. Now we're talking about this Slipknot case, and we'll finish up on this, then I'll revert back to the ICANN 84. But so Slipknot, right? They're a band. It's like David, like Twisted Sister. Or I guess what I'm getting at is there's bands that were popular now, not so popular, but Slipknot still is a pretty big band. I know worldwide they've sold a lot of records. It's just when you get, you know, 30 years into it, right? You're playing more clubs or fairs, they're still pretty big, probably bigger than Twisted Sister. But, I like bands like Tesla. Remember that band Tesla? That was before Tesla was Tesla. That's
I
my type of
did.
band.
They came Signs. That song Signs,
Yeah.
right?
Signs everywhere. Yeah, I really liked the singer for that. And they had What You Give. Anyway, great. I remember running to that CD. But anyway, I liked it. But there's bands super famous, and then all of a sudden now they're still, sometimes they have, REO Speedwagon's not even that big anymore. Okay, so this band, David said, still big in Brazil. But Jeff, so um, are they, because basically this case is going to hinge on, they had PPC links. This new owner of this domain name, Slipknot, had Giant Panda landing page, parking, and it was selling these Slipknot concert tickets for this band and Slipknot merchandise. And Slipknot, as I mentioned, they have slipknotmerch.com and they're on slipknot1.com. Well, all right, so basically they never went after the name Slipknot, probably didn't think they had a case for it, but they waited around finally till some new owner gets it, parks it, doesn't know what they're doing, and can this alone, these parking, links, these PPC links, can this, be reason for them to lose their name in this ACPA case?
Yeah, I mean it can because again, Virginia, where it's filed, is one of those jurisdictions that basically says that every, not just every renewal counts as a new registration or a registration under the ACPA, but it also says that that if it goes from one party to another, you essentially, unless you could show that it's part of a um, like a corporate transaction or something where it's a sale of the entire company and the domain kind of went with it, unless you could show that, each new owner is it's as if it starts the time again. So the fact that the original name was, what did they say, 97 or something like that? No, a long time ago. Let's put it that way. The new owner doesn't get any of the benefit of the benefits of the previous owners, and the PPC page is, that is strong evidence of bad faith. And so yeah, they sometimes waiting around does in fact help, if the new owner does some stupid things. So be careful, domain investors. If you buy names and that name, even though that name's been registered for 20, 30 years, if you're a new owner and you mess up, you could be on the hook. Um, so yeah.
Yeah, I always bring up the name Purple. Could you imagine getting Purple? You just bought it this year. You got a great price on it, and then all of a sudden you got it parked, and all these mattress, ads come up, and then this Purple mattress company comes after you, and you lose it. Now, I think that's even more generic than this, but Slipknot, generic term. It's just weird that, yeah, you're responsible for the landing page. And David mentioned that over at Giant Panda, you can, say include these types of links or related to this or not. But it's just, we see, this is an actual court case, not a UDRP. Like Jeff said, it's filed in district court in Virginia. So it doesn't matter whether it's just a hearing, a UDRP hearing, or a full-on court case. If you got PPC links that are, you know, uh, infringing or competing with um, the mark owner that's filed the case, it's not going to look good for you. It's just, to me, when it's a generic name like Slipknot, they should have, you know, if they can show, I don't know, how would you show? Because you would lie and say, I didn't mean it, blame it on the parking company, but yet I did receive money and the parking company did receive money for these clicks. But anyway, all right.
So another interesting thing. So this is the same court I filed another case in that we talked about last week, the best drinks prosecco case, and this case is numbered 1777. The other case that I filed is 1711, which means that in between October, when did I file? 7th at the end of the day, so really October 8th and October 15th, 7 days, there were 66 cases filed with that court.
Gee,
Anyway,
yeah.
random trivia.
No, but
But
it's a lot. I thought you were going to say over a few months, but you're right. A lot of cases filed, and that's in a federal court. Um,
right, and remember, this is all civil matters, so it could be anything from a divorce to no, actually, they would have a different number. So it could be anything, any kind of contract or civil matter.
Let me get David back up here. But Jeff, before we move on, I told everyone, of course, they can go to dnlshow.com, check out the outline. ICANN 84. Okay, so it's coming up. I know you take off Thursday and head over to Dublin. I was saying, I really like attending virtually. I mean, I love that they say, you can attend in person, attend virtually. I really like the meetings. I like how, all the different sessions. I mean, it's fun being at home. You can just, like I said, it's on their local time, the sessions, but you can just jump in and jump out. About the sessions you're going to attend, since the TLD stuff is heating up, and I'm assuming there's going to be sessions, and of course that's one of our primary businesses. What sessions are you planning on attending? Some of the TLD sessions, the new G sessions, but what else is on your radar to attend? I know you've been to a lot of the meetings and you've already been there and done that, but what are you looking forward to ICANN 84?
Oh, that's different. What am I looking forward to versus what sessions I'm going to go to? Um, so, I mean, I always look forward to the meetings just to see everybody. We get together 3, 4 times a year. Um, and it's good. It's one central place to see all of, customers for Hip Hop, for example, the registrars, um, you know, app, prospective customers that are applicants, as you were just talking about for new TLDs. But as far as the sessions, yeah, the new TLD sessions, but then I'm one of the officers of the registry, the GTLD registry stakeholder group. So I'm, committed to go to those sessions. Um, yeah, but it should be fun. Dublin, it's going to be a little bit cool and rainy this time of year, but I'm so glad it was moved from Oman, which is where it was initially scheduled, to Dublin.
Yeah, where is ICANN 85? I didn't look it up yet. I know it's.
It's in India. Um, I'm trying to remember Mumbai. It's in
Oh,
Mumbai in
in
March. It's always the longest time period between the annual meeting and the first meeting the following year. So yeah, it's March, mid or late March.
Yeah, and I wonder. I see Ragu's here. Don't come up, Ragu. Not till the end if you want to. But anyway, I wonder some. I always liked when they called it Bombay. Dr. Bombay. That was my guy. I'll be with
Also, keep in
Bernard
mind that
Fox was his name. Yeah.
the next meeting is going to be, a month away from the opening of the application window. So it's coming quickly.
Yeah. No, definitely. And we got one more topic we're going to talk about. And then, of course, well, I'll just get to it now. If you are applying for a TLD in ICANN's next round, go to tldstrategies.com and schedule a meeting with Jeff and I, and we'll tell you how we can assist and really just a, no cost consultation. Get them while you can. That's not going to last long. But no, it is heating up. And if you are interested in, participating and applying, but you're like, listen, I don't want to, I don't plan on applying myself. Is there any way I can become part owner of a registry and become, just a participant in an application on a team of folks? Well, that might be possible. Go to tld.fund and take a look at the presentation. And if you're interested, then, go right back to TLD Strategies and schedule a meeting. But if there's, we have some interest folks that would like to own a registry someday, but not by themselves, don't want to spearhead it, would like to be part of a team. And, we talking about that possibility, an option for folks. Okay, I'm trying to get David back up here. Let me invite for the 8th time, David Michaels.
Yeah, can you hear me now?
Oh, yeah. Sound good. You're back up here. Smooth as silk. Yeah. Okay, so this next story, then we're going to get to our cases, okay? This next topic, really, we won't get into the specifics. I'll tell you a little bit. So this guy gets an offer. Basically, a broker reaches out to him for Go.ai. Okay, well, I immediately think, too, and Jason.com's in the crowd. He mentioned it on a post. Yeah, sound like I immediately think Disney anyway. Disney contacting a fucking broker saying, okay, this guy's selling this name. Can you get it for us? Who would want an AI domain name, especially Go, more than Disney? I can't think of anyone. And they're not stupid, okay? They were even messing with the metaverse. That's how smart they are. But so anyway, this gentleman, it was reached out and he said, I'm not. It finally came to he threw out a number and said, well, what number would you take? The broker's pinned him down a little bit. From what I understand, we need to see all the communication because I've gone back and forth on what, but the gentleman was talking in Ish's room the other day, Muhammad. He's the owner of Go.ai. And the longest story short is he said, I'll take 1.4 million for it. And the broker came back and said, you know what, it's more than they want to spend, but they have agreed to it because they would like to just put this thing to bed and acquire this name. So go ahead. And from what I saw via a message, it said, let's formalize this. And that makes me think that, so it wasn't formalized before, goofy broker says, if they're saying, because I would have acted like, thank God you already formalized this by saying that. But now to get to of a more generic setup, when there's negotiation, and I want to ask my two co-hosts here, the lawyers, when there's negotiation and you say, when you just say my asking price is 1.4, that's, so let's go this scenario, and then you guys can answer. I own a name. My asking price is 1.4 million. They come and back and say, we'd like to give you half that. And I say, no, my asking price is 1.4. And then they come back and say, you know what? We will meet your asking price. Is that a meeting of the minds? Is that a contract? Who wants to jump in it?
I was waiting for. Go ahead, David.
Yeah. So this is actually a complicated situation. So if a person accepts your offer before you rescind your offer, it's a contract generally. There are some exceptions. There are some complications in terms of value and jurisdictional issues, statute of frauds, and so forth. The UCC used to govern this, but doesn't appear to anymore. What do you think about all that, Jeff?
Yeah, I mean, when you said statute of frauds, just for everyone else, that means that certain contracts have to be in writing um, even if you have an oral agreement. But a general purchase and sale can be oral. Sometimes it's hard to prove that that deal was actually made. So it's always preferable to get things in writing. Um, but yeah, I mean, there's been many cases that have been fought based on what two parties orally agree to. And usually the best cases are ones where it was an oral agreement followed up by a writing, that says like this email confirms, we agreed, blah, blah, blah. But you have to know it. It's hard without knowing all the facts and circumstances around it.
Right. You would
Yeah, like for
need all
example,
communication.
if the buyer had actually put money in escrow to close a deal within the 2 hour time frame that this occurred, then that might have been enough to constitute part performance and solidify the deal. Given that in the situation, the seller is in Ontario, Canada, and the buyer, well, we don't know where he is, but we know the broker is a big broker. It could be Sato in Boston, but it might be the individual in Florida. So there's so many jurisdictional issues going on here. We don't know actually what happened, but in general, if you say I'll transfer you the domain name upon payment, well, the payment is enough. You don't need any further writing.
Yeah. The bottom line is this. So every case is different. You would for that case that I mentioned, Go.ai, you need to know every communication and then you would dissect it. And if, like Jeff mentioned, what David too is, if it's real estate, I know I'm talking about California laws. In real estate, you guys can talk all you want. It's going to have to be a written contract. And also, people mentioned before about automobiles. Automobiles, you have a right, even if you buy it and you've given them the money in California, you have the right within 2 days, I think it's 3 days, you can take your car back and say, I changed my mind. I changed my mind. I already gave you all the money. I want all my money back. So different industries have different laws, different rules for different reasons because there's, history there of courts deciding certain things and then laws change, like I said, in the automotive space where you actually can have, you decide you want your money back the next day, you can go and do that. Now, so domains are different, but one thing in Domain Gang commented on this particular, he said technically either party can retain the right to change their mind before formal contracts are signed. No, we just said it doesn't have to be that. No one can just change their mind because there was no contract signed. It happens a lot. Sure, a buyer says, you know what, I want to buy that from you. We finally negotiated a price. I'm going to buy that from you for 20 grand, and the seller's like, fantastic, 20 grand it is, and then the buyer is fucking gone, and you're like, that's bullshit. That was a contract, and especially if you have a specific, if it's verbal, of course it's nice to have it recorded, right? If it's verbal, but if it's still a contract. So I want everybody, it's not like, schooling everyone, but everyone to know, yes, if we have an agreement, it can be verbal is as good as written. When I say as good as written, the reason it isn't is because then it's the proof of how do you prove that you had a verbal contract, specifically said certain language and so on. Well, if you have it recorded, then it's just as good as being written down because then we have the specifics. But anyway, with this case, yeah, well, you would need to know if someone just has a price. I got this price of here, like a buy it now price, and it's 20,000, and someone comes along and say it's not a quick transfer like Afternic, and somebody says, "Hey, I see your price, Todd. It's 20 grand. It's on your own lander. I think I want that for 20 grand. How do I pay?" Well, then I can say, you know what? That price hasn't been updated. There's things, there's different instances where no, that because of what's trending, and no, that was my listed price, but that has changed. So then I would say, the seller has a much stronger case. It doesn't mean a buyer can't try to say, listen, he listed it. I sent him an email. If I had written back, and I won't get into this, hey, you see the buy it now price, that's it. And then the guy goes, okay, then I'll take it. I would still possibly have some defenses. But the point is, you need to know every communication, everything that was said back and forth. Was there a really a meeting of the minds and agreement? And then, but still, before any money changed places, sure, people back out all the time. And that's when folks are misled in the domain space. They think nobody sent any money yet, so there's no deal. Listen, there can still be a contract, there can still be a deal. And that's why, we have court cases, because somebody didn't follow through and make payment, you know.
Right, but also remember like the extent of damages, right? So contract cases are interesting because, it's not like a slip and fall or a tort case where you get things like, you know, pain and suffering kind of damage or punitive damages or anything like that. Breach of contract, you seek to recover what your actual damage is. And if it's only, if you have an oral agreement and someone backs out after 2 hours and you want to sue for breach of contract, it's really not much you're going to show as to damages, right? And so that's kind of one of those things where if I were an attorney, I would say don't even bother, right? Because you're not going to be able to show that you justifiably relied on that contract and went out and did something else in reliance on it, right? That like so, the case, one of the cases I've been working on is where there was a breach, but it had been 60 days, and a lot can happen in 60 days in reliance on the fact that you have an asset and then that asset is pulled or never sold or whatever. But 2 hours, as an attorney, I'd say, well, yeah, that was a crappy thing that was done to you. But unless you could show any damages in that 2 hour period, don't even bother.
Yeah, great point, Jeff. I mean, and that's it. If you come to an agreement with somebody and immediately 2 minutes later you say, "No, I want out of it," that is a big fact that needs to be included. Like Jeff said, 2 hours. If it's 2 days later, somebody may have sold some stock to get cash. They might have a big capital gain expense. So definitely for whoever is backing out of an agreement, it may be a contract. The sooner you do it, especially like I said, is no, the other person hasn't made any moves that they can usually say, "Hey, this is how it affected me. I had taken these actions, which had cost me money, and so on." But very interesting. This ought to be interesting. We got to get to our cases. I got Jason.com and Ragu, so they know we speak at the end of the show, so we can get to our cases. But I'm going to be really nice just because it may be on point. So I don't know. I don't see him here, but Jason.com, thanks for joining us. What comment did you have?
Hey, yeah, so I'm pretty sure pretty much domainers ran into this issue where maybe they've agreed on a domain name for sale and they've sent it to escrow. And then when you're in the middle of an escrow transaction, you received a higher offer for, say, 10K. So what happens, in that situation? I'm pretty sure some of us have ran into, had that option, or it happened to me before. So yeah, what's the case on that?
Did you take the higher offer and did you lock it in, meaning make sure you
Fuck
did?
yeah, I did, dude. I took that offer. I was like, oh yeah, dude. So yeah, I broke a escrow transaction agreement. This was a Stephen D'Angelo case where someone offered me for a cannabis name, sent it to escrow at like, I don't know, 2,500, $3,000, and then Stephen D'Angelo calls me up. They were doing some cannabis institute over in Boston, and I had their name, and he's like, dude, I'll give you 10K right now. And I try to explain to him, I was in the doctor's office. I think I was like sick as shit. Right. So I was getting like, checked out, and he's like, dude, I'll give you 10, I'll give you 10 grand right now. I'm like, all right, let me see if I can, notify escrow. And then I called escrow, see what the process was. And, the thing was, I was waiting on the payment for like, 6 or 7 days. And I'm like, why the F, am I waiting this long for the payment? So escrow allowed me to break the contract or agreement. And then I took the higher offer with Steve.
Yeah, and Steve D'Angelo's Harbor Side. But anyway, interesting, Jason. We'll get to Ragu here in just a second, but I was going to say, so at least escrow allowed for it because of the delay. The buyer should have jumped on it, but still, in normal cases, ethically and professionally, once you've agreed and somebody else is doing it, it's like when we do selling a name to somebody for $50, somebody else says, I'm going to give you 150, whether it's even in one of these rooms on X. Professionally, ethically, you've already come to an agreement with the first guy. You don't pull the rug out, but you have a little leeway there. They didn't pay you fast. Hey, Ragu, what's going on? Nice to have you.
Thank you, Todd, and good afternoon, gentlemen and ladies. Same thing, but I wanted to put attention to Jeff, other way around. For example, which is not example, it happens to me last year, 5-figure domain name. I saw it on a GoDaddy and I buy it now, and I bought it, gone through my cart, and then it didn't deliver. Then I got involved with a broker of GoDaddy, and the bottom line came to is the owner changed his mind. He doesn't want to sell that low price. And as Todd said before, price was not updated. What do you mean by that? I don't understand. Now, I even went further, like with the transaction, and still didn't go through. And even with the broker of GoDaddy, didn't go through. And now, do I have a case? This is my question. Like, I'm not putting a case through, but I'm just saying it's not always maybe the seller fault. Sometimes, the brokers or how would you take responsibility as a GoDaddy or GoDaddy broker where they're actually publishing for sale domain name to buy it now?
Yeah, I mean that all goes to the reliability and credibility of GoDaddy, right? And so if GoDaddy's going to have a lot of cases where um, it's offering a broker and it agrees and with in a deal with a purchaser, but the ultimate seller backs out, that affects that impacts on GoDaddy's reputation and credibility. I don't think they would get very far if there were a huge number of those cases. I think that would hurt their business. But stuff like that happens, and GoDaddy can't really control that. Um, I think they can do a lot better, GoDaddy, to make sure that names that are on the expiring name auction are actually expired and free of any claim by the previous owner than what they do. But they don't, that's one of my complaints. But, it's hard if you're in this case, like a completely neutral broker. Um, it's hard because I'm sure every broker has faced a situation where a client of theirs they thought they had a price that their client was willing to agree to, and then the client backs out. And then I would think most brokers would not want to keep that client as a client for very long if they repeated that. But from contractual damages standpoint, like I said, it's very hard
Yeah,
to
it is hard.
establish.
It is hard, Jeff. But surprisingly, 3 months later, a broker contact me for a higher price to sell me that domain name. And when I questioned, why is that? Why is the high price now? And the answer I got was, which is odd as well, saying that it's a new seller, not anymore old seller, because I demanded to get rid of this seller because if he's not sticking to his word, and they say we'll take an action. But 3 months later, when I get another inquiry from the broker to me to seek from buying it and higher price, and I denied it. But that's even further step. You can see nobody is looking at the ethics or law and order and what we all talking about it. So the bottom line is these things is purely will work on ethics or the way we say it, shake hand, man to man type of thing. And yeah, and the suggestion is writing down, and contracts and work from there on. Yeah.
Yeah, I mean, look, again, like I said, it goes to the credibility of the provider. So if you're not trusting any provider, whether it's GoDaddy or any other provider, Dine or whoever, if you don't trust what they have to say, then you tell the broker, sorry, I don't want to deal with you. Sales works on trust, and without trust, you don't have anything. And I mean, that's the way most contracts are. You can have lots of things in writing, but a contract is only the first step of your actual business relationship. And if someone breaches that contract, even if you can't get monetary damages, they've ruined that relationship forever.
Yeah, it happens all the time with a lot of people. And I think we're only highlighting which is like a 6-7 figure domains or high profile type of domains. We can talk about it, but I bet you this type of scenario is coming up everywhere all the time, either from the marketplace or the buyers or the sellers or the brokers. You know,
It does come up a
that's the way I
lot, but
believe.
we got, as you know, we got to get through this stuff. I look at the clock all the time. I know it's rude. I'm looking at the clock, but I will say, Ragu, we're friends, okay? But I will say, Ragu's part of more negotiations as a buyer and seller that never ever complete than anybody I know. He's involved in this one, that didn't go through. Okay, Ragu, you can yell at me later. You know my number. Anthony, nice to have you here. We want to get to our cases, but I want to give you a chance to comment or have a question first. What's going on?
I must have pressed the button inappropriately. I'm sorry about that. Take me off.
What kind of person does that? I always imagine you walking down the street, waving to people in New York, with a cup of coffee, and then you hit the button wrong, and you're like, "Yeah, talk. I'm on stage now." All right, Anthony, thanks for joining. Stay here. Maybe you'll get some followers out of this thing. All right, it's Profit.com is our first case that we're going to cover today. I'm very happy that Igor is joining us. He represented the domain owner in this case. And you might think when you hear first the case, Profit.com, yeah, Profit.com, you would think, well, who's filing a UDRP to try to get this name? And boy, we think it's, should be cut and dry, that, yeah, hopefully this domain registrant, the owner, doesn't lose this name. But it's not as cut and dry as you think. So I'll set it up. Profit.com is the domain name. There's a company out of Brazil that filed this complaint. They offer like tech solutions in the financial markets, let's say. They filed this against a UK resident, and Igor, like I said, represented them. So Igor, thanks for joining us. I wanted to ask you, how did this domain owner, find you? And then tell us a little bit about why this case was not, give us some facts about why this case wasn't as cut and dry as one would think. And thanks for being here.
Yeah, hi. Hi, Todd, can you hear me?
Very low, very, very low.
Let me try. I don't know if it's better now.
No, it's still pretty low.
Let me try without my
Yeah, that's a lot better. It's still, you're about 50, 60%. Okay. That sounds pretty good.
Okay, great. Thank you. Hi, Todd, and hi, Jeffrey, David. Hi, everyone. Yeah, I mean, if you look at this case and the domain name, you would think that this should have been very, very easy case. And again, I mean, to be honest, it wasn't a very difficult case, but it was a lot trickier than it would look like just by looking at the domain name. Well, first of all, basically, we connected on LinkedIn with the registrant. And then we basically started chatting, and he asked a few questions, and then we had a call. And basically, I explained to him how the UDRP works, and he explained his story and the story behind this UDRP complaint, and then we decided that let's work together. And I mean, just to give you some background of this story, well, there is a Brazilian company, and they first sent a cease and desist letter to the registrant, to this guy who is basically, he runs his startup, his UK-based startup company, and they offer a platform for trading and for investment. So basically, they help people make better investment decisions. And this Brazilian company, they offer some kind of similar product, that software that also helps, businesses with some, investment. let's say, investment and trading stuff. And this Brazilian company said that, look, there is this guy, he registered this domain name only recently, because the domain name itself was registered back in 97. But this Brazilian company argued that he registered this domain name in 2023, and when they already had trademarks in Brazil. And then they said, look, he's offering competing services, competing product under this trademark, under our trademark. We sent him a cease and desist letter, and they did actually send a cease and desist letter. He didn't respond to the cease and desist letter, and they said, look, he's like, he's bad person because he didn't respond to our cease and desist letter. And they also found out some negative reviews about service of my client, of the registrant, because actually there were some negative reviews written by some users of the platform, this profit.com. And what else they said? They said that, look, he has a Portuguese language version on his website. It means that he's targeting the Brazilian market. He should have known about our company. So they kind of try to argue targeting, even though this was not a ERP case, but they
Igor,
tried to.
On the Portuguese, because that was something I was confused about. So I've gone to the site, right? And so the automatic version that comes up for me is English because of where I am. I'm assuming that the automatic version that came up for the complainant was the Portuguese version. And to me, I guess the decision didn't do a good job on saying, yeah, well, of course it's translated into a whole bunch of different languages depending on where you're accessing it from. And I think the whole Portuguese thing was kind of confused in the decision to make it sound like it was only targeting Portuguese. The decision was written in a very unclear manner, I think.
It was a very short decision, and actually both the complaint and the response were quite lengthy. I submitted like a 19-page response, and we provided 12 annexes with lots of details, including third-party profit trademark registrations, screenshots of third-parties' website offering similar products and services. And the complainant submitted 40 annexes, and also quite a detailed complaint. And the decision is kind of very short. It doesn't reflect the whole story. So, the point was I'm making that even though to me, clearly this is not a cyber squatting case. And the complainant's lawyers, they should have realized that this was not a cyber squatting case. But maybe it was not as obvious, as some people would think if you don't know the whole story. And the decision itself is quite short. So not everything that was submitted is in the decision.
Well, let me say, Igor, you're right. We just talked about that Slipknot, case. And this is somebody who acquires the name, much later. And, in this case, what can you tell us about the acquisition of Profit.com? So this guy picked it up really at the end of 2022, started using it in 2023. Yeah. It's not an inexpensive name. What can you share with us about, what type of investment, it's not just any name. Profit.com, pretty big.
Yeah, exactly. Yeah, basically this domain name was first acquired from the initial registrant. So the name was acquired in 2016 by the investor of Profit.com company. Then in the end of 2022, this investor, comes in, and basically he offers this domain name to this startup, to this British startup. And this British startup pays over $1 million. I think it was $1,200,000 or $100,000.
Yeah, that was in the decision. Yeah.
Yeah, and we submitted the documents because we wanted to be very transparent, about the history of acquisition of the domain name. Well, we didn't try to argue that, he bought this domain name in 97. He didn't. He bought it in 2022, in December 2022. And then he kind of rebranded his product, his service, because initially it was called Darkcube, and then he rebranded it into Profit.com because one of the company's investors basically bought this domain name and then kind of sold it to the company. And that was the story behind this. And again, we had to explain this, provided some documents as annexes. And even though to me, as I said, it was not a cyber squatting case, and probably they deserved an RDNH filing, I didn't ask because I didn't believe that the panel would find an RDNH, in these circumstances. But what I did in my submissions, I actually pointed out to some inconsistencies in complainant submissions and some kind of outrageous claims. I mean, they tried to argue targeting, but they made some claims that didn't make sense. But I mean, the panel didn't consider RDNH as I thought, but maybe they could have.
What was the visual similarities to the complainant site? I mean, I'm glad they said it was only coincidental, but what did they try to argue?
They try to argue that, the respondent copied the complainant's logo, profit and P, the P logo, in circle, I think. And they also said that, look, they also appropriated our intellectual property, copied our design and layout. But I mean, that was not true. I mean, there's no similarities. I mean, and even the logo was different. So this was clearly like a misstatement, like not even an exaggeration. That was, I would say, I would consider this false.
And what's the primary site that the Neologica system, what do they use?
They're on
They use some
neologica.com.br and
neologica.com. Yeah, they don't have any profit domain names. And again, we also provided this in our response. We said, look, they don't even own any profit domain names, not even in Brazil, not like .br or something. So they have no connection except the name of one of their products, but it's only one of their products.
I'm wondering if just before we move on from this, okay, so you're allowed to sell some of the same services. I'm wondering, Igor, if this was Profit, say it was called Profit Bank, and they're out of Brazil, and then they feel like, whether or not they establish that they're super well known around the world, but they do business internationally. Then can someone have if they picked it up later on, 2022, 2023, and then they want to be Profit Bank out of the UK? In this case, they're both in the financial services, but really I want to ask all three of you guys, is that okay for the new owner of Profit.com to get in the banking business if the Brazilian company was a bank?
I mean, as Igor said at the beginning, this case is really more of an infringement case than cyber squatting, if there's any case at all. And so the answer I would say to you, Todd, is yeah, they could use it for that. It should still not be cyber squatting, but it would more realistically be claims of trademark infringement. Unfortunately, some UDRP panelists like to go well beyond the scope of what they should. So I'm not saying some UDRP panelists would recognize that, but certainly I would think a respondent would make the argument that, look, first of all, we're not a cyber squatter. We're a legitimate business. We've been in business. The previous name of our product was, whatever it would, like R-Cube, I guess, in this case, right?
Yeah.
And, yeah. And so we're a legitimate business. We're in a completely different geographic territory. There's nothing, no evidence of any kind of cyber squatting here. And at most, the panel should, or at most all the panel could do is dismiss it in favor of, because it's outside the scope of the UDRP. I mean, not all panelists do that, but, where you have two legitimate businesses competing or claiming that the other legitimate business is infringing, it really should not be a case under the UDRP.
Yeah, and I would say that, I mean, with the case of like Profit Bank, again, it depends like what kind of evidence of targeting do you have, do you as complainant have, and what kind of evidence you can provide. Like, okay, is your bank really famous outside of Brazil? Is it known in the jurisdiction of respondent? What are there any other profit banks or banks named Profit? And what kind of arguments respondent can provide? They saying like, look, I never heard of this bank. We have hundreds of other profit banks in the UK or in Belgium, in France, or somewhere. And so, again, it really depends on the facts. And again, when it comes to a website, actually, is there any copying of complainants, like, I don't know, design, logos, and whatever? I mean, there was nothing here in this case. And in this profit.com case, I think it was not even trademark infringement, not even that. And even if, I mean, trademark infringement could have been only in Brazil, because they only had Brazilian trademarks. So they could have argued maybe trademark infringement, but in the national jurisdiction only, because they had no trademarks, no profit trademarks outside of Brazil. But, you know, it all depends on the facts of each case.
Yeah, I don't know. I mean, when you say that, because, right, Citizens Bank, I know there's a ton of banks called that. I think, they filed a UDRP against me. I think it was a Citizens Bank. But there's so many, tons of them named Citizens Bank, and they coexist. And sometimes they're going to have to, with certain names in certain, industries, they're going to have to coexist. They're not going to be able to prevent others from using it. But right, there's different facts for different cases. Well, that was a 3-member panel, complaint denied. So it was, fantastic.
Yeah. And sorry, just to add, maybe in the end, Todd, if I may, just kind of to conclude this, and just to say that, again, I believe that this was clearly not a case for the UDRP, and this shouldn't have been filed, and it was maybe complainant's lawyers' duty to tell their client, like, look, we shouldn't really file this UDRP complaint because we have no chances. They tried. I think they wanted, to file this Brazilian law firm doing some IP work, but probably maybe they don't understand the difference between like trademark claims and UDRP claims. But again, I thought that maybe for us, we shouldn't really expressly claim this RDNH, because I wasn't sure if the panel would support us anyway, even though, again, it might have been an RDNH, maybe it should have been an RDNH, but I didn't ask for these reasons, because it was not as straightforward as it looks like.
Yeah, I can imagine when you got, when the registrant reached out to you and you've seen every different domain name, but to see one that that's more than $1 million name, profit.com, the person certainly wants, great defense, some fantastic help, because you can't let it go the wrong way. And we see, like, when you acquire a name after a trademark, geez, you make a wrong move, sometimes it can be taken away from you. But yes, so I agree with you and Jeff there that this certainly, if anything, was a court case if they have a problem, not a UDRP case. But panelists sometimes just, at least this was 3-member. And finally for this, so was it your decision to go with the 3-member panel?
It was actually, let's say, respondent's decision, which I supported, but I actually told him, look, I think you'll be fine with a single-member panel, because I was pretty confident, even though I realized straight away that, we really we need to spend some time on this. But I told him, look, I think single-member panel will be fine. But he said, like, can we, like, increase our chances, because it's really valuable domain name, so I don't want to have any, I don't know, unexpected results, or, just to be dependent on a single person. I said, then we can go with the 3-member panel if you're fine. And he said, yeah, I'm fine, which I think makes sense in cases like that, even though it was an obvious case in a way, but still.
Yeah, there was no one that, there was not a panelist that, what do they do, Jeff, when you go against the grain? What is it, Igor, the word I'm looking for? Oh, dissent. Okay. Sorry,
dissent, dissenting.
That's from years of not drinking. Okay. Congratulations, though. Profit.com, the domain owner keeps it. Of course, like I said, a lot of people think, of course, yeah, but of course, let's say you don't want to go into these things without professional help. So congratulations, Igor. And so this next case, we're going to try to get to our next cases pretty quick. David, I wanted your help with this next one. I have some comments on it, but I want to get through it pretty fast. WhatsApp.ai. People might think this even more so than the first case, that of course this person's going to lose the domain name, right? WhatsApp.ai. Why would this person think that they can, register this and use it? And this respondent, this domain owner, of course, the name was Noam Cohen out of Israel, was the domain owner, was of course fighting against the big company WhatsApp LLC, the company that we all know about with the communication app. WhatsApp was the complainant. So David, tell us about how the respondent responded here and what they could have done to, get a better decision.
Well, the respondent is not the original registrant of this domain name. It was registered in 2017. He acquired it sometime recently, put up a half-assed website that, had a vision, but the timing looked suspicious, and it looked like it was just to mollify the UDRP panelists, according to the decision. Actually, I didn't actually see the website, but let's see. The other thing is, the respondent is based in Israel. I know that if he were to win the UDRP and he was based in the US, he would lose on appeal because, hey, WhatsApp is a famous mark. And that's a lot easier to win than anything else. So, right now the website is actually not even loading for me. So I don't know if it loaded for you. Did you see anything on the website, by the way?
I didn't. I know the respondent in this case, basically came around and said, I had plans for it. And he sort of knew the words. And Jeff, those words, I know, Igor, I don't expect that you took a look at this case, but the registrant said, hey, I am making these demonstrable preparations to do something here. The panelist said, you say it, but you really didn't show it. And the respondent said, I'm taking positive steps to avoid PPC links on my page. That's why I'm using a coming soon. So Jeff, he's saying all the right things. It seems like he just didn't have evidence to back it up. How did you see this case?
Okay, I hit the wrong button. Yeah, that's the problem. All he was doing was saying the right things, but there was a lack of credibility in what he submitted. I think they said he submitted all these things, in an exhibit, but none of it, like an exhibit to the response, but none of these things were actually, there was no proof that it was actually being done. There was no explanation by the respondent about what it, that why it was changed only after he got like a cease and desist letter, and certain other changes only after the complaint was filed, and then there was no explanation of what the latest thing on the page was. I'm forgetting the name. It was like a name of a company that he just doesn't explain. And that's the problem, right? You could say whatever you want in a response, but if you can't show some credibility behind what you're saying, and you can't show evidence behind what you're saying, then it doesn't mean anything. And it's just, oh yeah, someone must have told you the right things to say. And even though you're saying them, there's just no evidence to back it up. Now, one of the things I kept thinking about just as an issue was, well, let's take these facts and circumstances out. But this name was registered fairly recently. I think it was like August or something. And so the question is, if someone really just had plans and was making plans, would they be believed by a panelist? And, how does one get around that? And I guess it's by having certain things that are signed and dated, or receipts of even early things, something to make your story look like it's got some credibility behind it and that it's not just made up.
Yeah, this name was registered July 2024, and you hit on it, Jeff, and that is he was saying, I'm going to, here's where I'm going to put the disclaimers. Well, you didn't put the disclaimers there. He's saying in his exhibits the stuff that he was going to do, and it's like, okay, well, you're going to use it for this. You haven't shown us proof that you've made, really preparations to do it. You say you're going to put disclaimers there, but you haven't yet, and so on. And he said, the domain owner said, I got this because it's a play on the term "what's up." Well, isn't WhatsApp also a play on the term "what's up"? I mean, that's what I always thought when I heard WhatsApp. I thought that was the same thing. I thought it was interesting that the panelists did say, if you're doing an app about, if you're doing a website that's talking about what apps use AI, the panelists said, then why wouldn't you use what app? What apps? Here's what apps currently use AI. Why'd you put WhatsApp? Especially that's their friggin' trademark. But Igor, since you're listening here, is there
Yep.
anything this
Yep.
person could have done? WhatsApp.ai. Is there really almost any defense at all? Because if this guy really would have been developing something that was, showing apps that use AI, is that good enough? Because he really is stepping right on, somebody else's sort of unique trademark, WhatsApp. What do you think?
I think it would have been very hard for him to argue, even if he had been doing, something real, because I think WhatsApp like a really famous trademark internationally, and it's hard to argue that I had no idea about WhatsApp, what it is, and that it exists. And then again, it's a question of targeting. That panel anyway could have thought that, look, you still targeted WhatsApp because you just wanted to take advantage of the reputation. Again, he could have had better chances, let's say, had he been really doing something, or had he been able to produce some real evidence other than just statements and allegations. But I think, strengths of the trademark is very important. So when you try to develop a new product, if you're a startup, and if you choose a name which is kind of similar or identical to a famous brand, then I think you're in trouble.
Yeah, that one's just too big of a mark to think of any other possible uses for it. Really. Well, that was a transfer. Single member panelist. Adam Taylor was the panelist, transferred the name away. But this person that owned the name before he lost it, self-represented, probably, even if he did reach out to some of the attorneys I know, they would tell him, you don't have the evidence. You're saying stuff, but you don't have it. No one wants to be part of a sinking ship. But then again, better that this gentleman answered anyway, and it really thought he had all the right answers. But anyway, so this is a transfer. Let's get to our last case and we'll get out of here. The last case is ecorpmotive.com, Aeromotive. I think it's a great domain name. It's a fucking fantastic domain. It was registered back in 1995. Now, it went through some ownership changes, the company, but they make fuel pumps. So this company, Aeromotive LLC, was the complainant in this case. They were going after this domain owner out of Panama. Okay, so the complainant makes these fuel pumps. They, I believe it was it this one? Yeah, the race car driver, and I don't know, Steve Matusek. Anyway, so this race car driver started this company way back in '94. This domain was registered in '95. They've used, I think the gentleman had used aeromotiveinc.com, and he registered it back in '95 too, because this name was already taken, just a few months before, I think about 6 months before. But it's because it's a great name, and talk about just great. Aero as in air, AERO, but then motive, it just, the future. It sounds like a futuristic name for flying cars to me. So they were way ahead of the time. But anyway, great name, as all of us domain investors know. Fucking brandable. It's a beautiful name. Well, in 2020, some new owners came along, and what they did is they ended up not continuing on with the fuel pump business. They ended up having the name, or I'm sorry, that's the complainant. What these new owners did with the domain name, they were never in the fuel pump business. They ended up putting up some PPC pages on it, and of course, it had links that were competing with the complainant, and they also had, come buy this domain name. So the new owners of the trademark, they were like, okay, now it's time for us to go after this person. They have these competing PPC links. They have this buy domain, so they went ahead and inquired about it, and they got an email back that said $30K, which seems pretty reasonable to me after somebody owning it for that long. But the complainants didn't like that price. The new owner of Aeromotive LLC didn't like it, so went ahead and filed this UDRP. And because of the PPC links, that was very detrimental to the owner. But basically, it cost this domain registrant the domain name, because now, after all this time, you've put PPC links on here, and even though it's I think a good brandable name, the PPC once again come and bite you. Anyway, David, what do you think about this? What comments do you have on this case?
Well, there's 114 companies around the world that would love to have this domain name that have aeromotive in their names. Aeromotive is descriptive of cars that fly. So it's like there's a whole industry behind that. It's more, popular in the UK and maybe Canada than in the United States. But there are a lot of companies in the United States with the name aeromotive in it. There was Great Lakes Aeromotive before it went out of business. So, the registrants out of Panama, their business is probably running PPC ads. What could they possibly do with this domain name? Other than running PPC ads, they could have done a lot of things. They could have done, just a website about the history of cars that fly, and the right buyer would come along and pay for it. So what do they do now? Well, the name is registered through ENOM. If they want to file a complaint in an Ontario court, they can, because that's where Two Cows is. Two Cows owns ENOM, and they probably would win because the registration date matters, and it's a descriptive word. So you can bypass the U.S. trademark and U.S. trademark complainant. But, should the panelists have transferred the name? I have my doubts. But, given that they required it more recently, I'm not sure about the dates, who got the trademark. Whether the trademark was registered before the current registrant has the name, I don't know. So that's the only issue I didn't unpack yet. Did you figure that out, Jeff?
No, I mean, this case kind of seemed a little obvious to me, and I thought that's why Todd had sort of put that in there. Because I tried going to the site, and then I realized this case is 2023 or 2024. If I'm looking at the right one here.
No, it's 25. It's
All right,
2025.
I'm looking. Why did I think this was an older case?
It got decided in May this year.
Oh, okay, maybe that was it. Yeah, it was older. Okay, so it was earlier this year, so I couldn't see what was on the site. But to me, it seemed pretty obvious, just based on everything that they said. And then I think there was also in this case a large number of domains that they also registered, the respondent registered, that were found to be infringing, like Barclays and Adidas and Microsoft and Cold Stone Creamery and Minecraft. So I didn't really do any other research. Once I saw that, I was like, okay. It was pretty obvious which way the panelist was going to go.
The domain registrant was out of Panama. I'm assuming it could be, when you mentioned all those, Jeff, I didn't even see all those, parking company that was making money off of a lot of trademarks. That's what I'm just guessing. And then this one was one that I think great defense for, but maybe it was a parking company who just didn't want to defend it anyway. But the domain, right, David, doesn't resolve anywhere. So these companies go out and win the name. It's important to them to get it, and what I think a great name. And then you can't even forward it. It's just so ridiculous. They can't even forward it to Aeromotive Inc., which is the one that they've been on for years. But this is, if you go to a domain name, I mean, I don't want to recommend people do this, but if you were a brand and you go to a name and you think, we can't get our brand, that, like David said, there's hundreds of companies that would love to have this. Well, if you go to it and you see, look, if you know anything, and you see, look at these PPC links, this parking company, well, they may not answer. We may be able to get a name for $1,500, some $1,300, depending on what the UDRP service provider's charging you. But in this case, anyway, interesting that after all that time, in all those different companies, it could have been any one of the 100, I believe, that David mentioned that used this name, and they could have filed this UDRP and won the case because this parking company likely, was not was using it in bad faith. But, there's definitely a great defense here for anybody that wanted to defend themselves. But I say great defense, but if their intention was, bad all along, then the only way they'd have a good defense is if they lied. But all right, so ecorpcom doesn't resolve. It was transferred away by Warwick Rothney. Yeah, so we had 2 transfers. The last 2 were transfers. Igor had the win today with the complaint denied for profit.com. I appreciate everybody being here. I really do. Thanks, Igor, for showing up. I know it's late where you're at. Look forward to the day we get together in person. I really do. But thanks for always being a friend of the show and dropping in. Jeff, to my co-host, thanks. And David, thanks for everything today. Definitely to the audience. We appreciate you being here. So if you want to talk about domain investing, check out me and Josh on Thursdays. DNX show, 10 a.m. Pacific, 1 p.m. Eastern. No topic is off limits. Open discussion. Everyone can come on stage. We talk about domain investing strategies, topics, and just ways to make money as a domain investor. So thanks for joining us today. Enjoy your afternoon, your evening, your morning, wherever you're at. See you next week. Same time, same place. Take care.